Good evening, everyone. Thank you so much for joining us this evening. I know that there is a lot going on in the world right now, and I know that people probably are feeling all the things and having all the thoughts. So I just really want to send everyone some extra love and light tonight, and also just thank you for spending your time with us. You could have been a lot of other places, but you decided to join this call. So thank you. My name is Tamara Brummer, and I'm the Senior Advisor for National Outreach and Engagement at Demand Justice. And I really just want to welcome you this evening. We're going to be talking about West Virginia versus the EPA, a case that is being argued at the Supreme Court next Monday. I also want to start by thanking our wonderful partners on this call, the League of Conservation Voters, Public Citizen, and the Sierra Club. I'm really looking forward to talking to you all about this case and about the many ways it will impact our ability to combat climate change and to address the other important issues in the future. So we're just really lucky to have you all with us in the fight. This evening, we were supposed to be joined by Senator Markey, but as you can all guess, there are some other things that are happening in the world, and he wasn't able to join us. But we know that this is an issue very important to him, protecting our environment and fighting for a greener future. So we're really glad to have him as a partner in this fight as we work to protect and defend our environment and our democracy and all the other things that are so important to us. And we really wish that he could be here with us. But that allows us a bit more time with our really important and special guests this evening for this really important conversation. So what I want to do is really introduce our panelists this evening. So we have Tracy Lewis, who is the Climate and Energy Policy Counsel for Public Citizen, Doug Linder, Advocacy Director for Judiciary and Democracy at the League of Conservation Voters, and Andres Restrepo, Senior Attorney for the Sierra Club's Environmental Law Program. So for all of our folks in the audience this evening, you can give a virtual round of applause. Yay, welcome to our panelists to talk to us about this really important case. We are in this unprecedented time where we're seeing so many of the things that we thought were kind of foundational to our society and to our democracy now being under attack. And so this case is something kind of front and center to that. And so really just thankful and honored to have this really dynamic panel with us this evening to really share with us more about this case and what it means for the future. So my first question right off the bat is for Andres. So next Monday, the court is going to hear oral arguments in West Virginia versus EPA. Can you tell us what this case is about?
Yeah, sure, Tamara. Thanks for inviting me. I'm happy to be here. So the case is fundamentally about, at its most basic level, it's about the scope of EPA's authority under Section 111 of the Clean Air Act to take action that limits pollution from fossil fuel-fired power plants, specifically carbon dioxide pollution. And it's a very complicated case. There's a lot of moving parts to it, but really the question is, when EPA determines the amount of emission reductions of carbon dioxide that are going to be required at existing coal and gas-fired power plants, what kinds of emission reduction measures can EPA look at when setting the stringency of those targets? Specifically, can they look outside of the four walls of the power plant and look at things like the opportunity to shift electric generation from coal and gas plants on the one hand to new renewable sources like wind and solar on the other hand? It also goes beyond that question, though, and it confronts whether EPA can do anything that is not simply limited to activities within the four walls of a power plant. So, for instance, that would extend to any kinds of tradable emission credits or averaging or any kinds of other sorts of tools that don't simply happen within the four walls of the power plant. This is basically reviewing a Trump administration decision to repeal the Obama EPA's Clean Power Plan. And the Trump administration relied upon a very broad reading, or rather a very, I would say, narrow reading of the Clean Air Act that would really significantly limit EPA's authority to take significant action under this provision. And that's what's on review here. And one of the things that's really important about this case is that it doesn't just go to EPA's authority and it doesn't just go to climate change issues. It really, the petitioners in this case, which are a group of Republican state attorneys general and coal company executives. They're pushing the court to decide this case on principles of administrative law that could theoretically really constrain the authority of executive branch agencies to do things that Congress has tasked them with doing to protect our public health and safety, things like FDA's authority and really any agent, all federal agencies who interpret the statutes that Congress passed that created them. This case would put those questions and put that authority potentially in jeopardy. And so that's why it really is not just only about environmental issues or climate issues, but it's about government's authority in general to keep us safe.
Thank you for that. It sounds like, they found this thread that they can pull at that will unravel so much more. Like this is just the kind of like the Trojan horse. So thank you for that, that very succinct breakdown of that and what's going on. Doug, the petitioners in the case have asked the Supreme Court to overreach in a couple of ways. First, your organization and others argue that the court is overreaching by hearing the case in the first place. Can you tell us more about this?
Yeah, absolutely. Thank you, Tamara. And thank you for hosting, and thank you to everyone at Demand Justice. I think there are a lot of legalistic reasons we could point to for why this case is an overreach, but I think because what we are looking at is a more or less raw exercise of judicial power that's coming our way on this, I think it's important to focus on some of the big picture items, and I'm going to pull out two of them. The first is the Clean Power Plan, which is at the heart of this case, is not in effect. The Obama administration promulgated this in 2015. It got held up. It was rescinded by the Trump administration. It is not currently in effect. And because of that, because it is not currently in effect and the administration is not trying, the Biden administration now is not trying to bring it back into effect, there is no real case or controversy here. And there are not a lot of limits on the power of the United States Supreme Court, which is one of the most powerful, maybe the most powerful court in any major democracy over public policy, and especially because they serve for life, so which insulates them from political pressure. But one of those limits is they're not supposed to exercise their power unless there's an actual case or controversy before them, and in this case, there is not. So that is one. There is no case for them to decide. The other big item here that I think is important to think about in terms of the overreach is stare decisis. Now, I'm sure that if the court decides to do the wrong thing in this case, and there's still time for them not to do that, but if they decide to do the wrong thing in this case, they will come up with a lot of legalistic excuses to do what they want to do, to follow an ideological agenda, and in some cases to use doctrines that have only been created in the last couple of decades with really no textual basis in the Constitution, to do what they want to do. But I think the big thing to keep in mind here is in 2007, just 15 years ago, a 5-4 Supreme Court that at the time still had conservative control, or said to the Bush administration, not only can the EPA regulate greenhouse gases and fight climate change, in fact, they said the EPA must regulate greenhouse gases and fight climate change. And so you can bring in different legal issues to debate why they can or can't do that, but the fact remains 15 years in Supreme Court time is not a lot of time. So changing their mind on this, on such a huge issue like this, in such a short amount of time is not how it's supposed to work, for an important reason that's a limit on their power, but they can do it. And if they do it, it will be because we have the most conservative court we've had in living memory. And even though this has been a conservative court for around 50 years now, it has never been in that time more conservative than it is now. And that means that they are ripe for reversing existing law and changing a lot of things for ideological reasons, including this and many other issues.
Thank you for that, Doug. I'm here because I'm also learning things as well. I think that what's also very clear to me is that, it's not about what's actually happening. It's about this political agenda that's being made and it sounds like using legal maneuvering to implement policies and procedures that we, the people, may have already voted against, but this is able to legislate those policies. And there's a question in the chat. And so we have some time at the end for questions. So thank you, please for putting questions in the chat. My next question is for Andreas, is to kind of build on the last one. Is the other way the court is being asked to overreach is by ruling on the so-called major questions doctrine. I am not a lawyer, so what I need for you to break this down for me. Can you explain what this means and why it would be an overreach?
Yeah. Yeah, I can. And one thing I just want to say that I meant to say it in my very first thing that I said, I want to invite everybody here who is in DC to consider coming to a rally that's happening on Monday at from 9 to 11 in front of the Supreme Court building. Everybody who feels strongly about this issue is encouraged to come. We're going to have speakers from affected communities. We're going to be advocating, the environmental community is going to be advocating. It's not a branded event, so there's not a particular organization that's sponsoring it, but I just want to invite everybody there to come 9 a.m. in front of the Supreme Court building who's in DC and who's able to come. So the major questions doctrine, and I think this actually might bear a little bit on Anita Edwards's question. The major questions doctrine is something that kind of emerged in recent years. And it's a legal principle that we've seen pop up in a number of cases, but a lot in recently, in large part because, as Jordan said in the question and answers, that this case is sort of really about efforts by legal conservatives to really drive a stake into the heart of the so-called administrative state. That's what opponents like to call it. We like to call it public servants in agencies doing their job to protect public health and safety. But really, there's been an effort for, in all honesty, since the Roosevelt administration. This goes back 90 years. And it's been an effort by those who oppose the growth of agencies during the Roosevelt administration to do things like protect public health and safety, monitor Wall Street, protect consumers, things like that, things that we all think are critical government functions. Those are things that really started happening in earnest under FDR, and that a lot of legal conservatives have been trying to roll back for 90 years. And this they see, as Doug correctly mentioned, they see this as their opportunity with this Supreme Court to finally really make huge headway on that. And that's one of the things that's really concerning about this case. But so the major questions doctrine is a legal theory that involves just this. And the idea behind the major questions doctrine, it's a principle that says that when a federal agency is making an effort in some sort of regulatory action to do something that is really outside of its lane, that's not normally what it does, that would have very significant or vast economic and political consequences, then in some cases, the courts have basically said that agency cannot do that unless the law that Congress passed authorizing the agency to act was explicitly clear on that issue. And that, in a way that federal statutes normally don't have to be. So basically, unless Congress basically pre-authorized a particular activity or regulatory action, it wouldn't be, the agency would not be able to do that. And that's what came up recently in the vaccine mandate case. The court held that because the Occupational Safety and Health Administration, or the Occupational Safety and Health statute, did not explicitly give OSHA the authority to require vaccines in the midst of a pandemic, that this decision, that they simply couldn't do it. And they thought that it was outside of OSHA's normal lane because it was dealing with a pandemic that occurred everywhere, not just in the workplace, as if there are pandemics that only exist in the workplace. But so that was an example, and that's a situation, that legal question is squarely presented in this case. We think that it's completely inappropriate for this case because we think that really the court should simply decide this matter, the interpretation of the Clean Air Act, Section 111, by simply reading the words that Congress wrote and deciding whether or not the petitioner's theories make sense. But they are saying, no. Really, the court has to consider that because the potential for EPA to rely upon certain kinds of emission reduction measures in some theoretical situation could have significant consequences. That therefore means that unless there's some pre-authorization language in the Clean Air Act, that the agency has to basically be halted in its tracks from doing that, even though, as Doug pointed out, there actually isn't a live regulation on the books that they're actually interpreting. So this is all by way of saying the major questions doctrine is a tool that legal conservatives are increasingly relying upon and are basically going to be arguing for it over and over and over again when they challenge government regulations, because they think that it's a way that they can achieve their long-standing goal of really striking a heart in the regulatory process.
Thank you for that. Thank you both, Doug and Andres, for like this breakdown of why this is an overarching case and why this is so important. I saw an article today that kind of had a headline that was like, this case might not seem that important, but it's actually super important. And I think you both laid out what's really at stake here and how this is a kind of like this maneuvering to do some much broader things. Andreas, real quick, there's a question in the chat. It says conservatives argue that there weren't large federal agencies at our republic's founding, so that can't be the authority in the Constitution for agencies like the EPA to do what they do. How would you counter that argument?
Yeah, well, I mean, for one thing, there were agencies at the founding. There wasn't, the EPA didn't exist at that time, but I would argue that the framers of the Constitution set up a structure that was meant to adapt to the country as it grew and as it expanded. And one of the most important things that Congress, or that rather the framers of the Constitution included, was the authority of Congress to regulate interstate commerce. And so things like the EPA, the Food and Drug Administration, the Securities and Exchange Commission, all of these kinds of agencies, that's what they do. You know, at the founding, there was not nearly as much actual interstate commerce as there is now, but there's no denying that power plant emissions are in fact, massively involved, part of the interstate flow of commerce. Now, the question as to whether, the executive branch can be organized in terms of agencies, I really think that that's something that, I think it's a specious argument to claim that they're simply, that because there were no such agencies at the time in 1791 when the Constitution was ratified, that therefore for the next 200 or 300 years there simply can't be. I think that the framers of the Constitution would be dumbfounded if they thought that that was still, that whatever they were doing would still be the exact same principles, or at least the same specific practices that they used 200 and some years later. I'm not saying that, the design of the Constitution and that the terms of it don't matter, but I'm saying that the language that was included in the Constitution is flexible enough to allow for the kinds of things that we do in modern government. And the vast majority of the American public agrees with that as well. It's really a relatively small vanguard of lawyers and political activists that have been trying to claw away at this for however many years, but it's not something that the majority of the country supports. So, to some extent, it comes down to methodology. If you're an originalist and you believe that only the original words of the Constitution as they were understood in 1791 are all that matters, then, maybe you'd find that argument more persuasive. But I think I think that there's much more supportable arguments for a flexible constitutional design.
Thank you for that. And yeah, I think that myself personally, I think the originalist version doesn't work in my favor.
Right.
So.
very, very good point.
Yeah. So I kind of, but thank you for that. Thank you for that question. So Doug, what do you see as the possible outcomes in this case?
It's obviously a great question, and I want to start by saying I 100% agree with Andres about what the outcome should be, and about the major questions doctrine, and about how originalism plays into this. And I think it's important to keep in mind, as we think about that particular piece, the founders were not originalists. Originalism itself, ironically enough, is a modern invention that came centuries after, and it was pioneered by Justice Scalia, who passed in 2016, arguably the most influential figure in the conservative legal movement in the last 40 years. Justice Scalia was once asked why he didn't take his originalism to the point of trying to abolish the entire administrative state, as some extremists on that side currently want to do. And his response to the interviewer who asked him that question was, and I quote, "I'm not a nut." And yet, here we are. So what are the possible outcomes in this case? Well, first, the outcome should be, interpreting it as Andres said, and following, by the way, the hundreds of members of Congress who submitted briefs to the court, talking about how the EPA does in fact have this authority. Congress has repeatedly established that, and they should not rely on failed efforts to change that in Congress in order to determine Congress's intent. But in terms of the actual potential outcomes here, hopefully they will dismiss the case as improvidently granted or interpret the Clean Air Act in a way that's consistent with the science and all the better lawyering that's come on this. To the degree that they decide to do the wrong thing. It's not too late for them to do the right thing. But if they decide to do the wrong thing, there are a few different ways they could do that. And it could be bad, or worse to varying degrees. And part of why it's in varying degrees is that they're relying on doctrines that have been made up in the last couple decades. The major questions doctrine is as old as the movie The Lion King. They came out in the same year. It's younger than AOL, younger than I am. I'm 32. So it's not something that's in the Constitution that they're drawing on the text about how they should interpret these things. But I will say this, if they decide to do the wrong thing, whether to a lesser degree or a greater degree, the outcome will be harm. Harm to our environment, harm to our climate, harm to our clean air and water, harm to the marginalized communities who stand to lose most when we allow these environmental harms to take place, and beyond in the environment, harm to public health, harm to public safety, harm to workplace protections, harm to every facet of the United States government's ability to protect less powerful people from more powerful people. And that is the point.
Thank you, Doug. That's right. Also, wow, The Lion King. So it sounds like this doctrine, I'm older than some of the some of the doctrine that is shaping though the future of our country, which is really important to know, to kind of put that into context for us. So thank you. So Tracy, to kind of build upon that, how could this case impact our ability to address climate change and specifically moving forward?
Oh, well, Tamara, thank you so much for your question. It's so wonderful to be here with a great panel as well. I'm learning so much. This is better than law school class, I just have to say. I know what questions I'm getting. But to your question of how this will impact our lawmaking, our policy making going forward. I mean, as both Doug and Andreas just said, we're discussing the complete unraveling of the federal government as most of us know it and understand it. And as Doug really just broke down perfectly, there's no place in our country that will be untouched. I mean, in law school, my professors would say it would be a parade of horribles. This net effect of each domino falling, causing another greater harm. So, but I did want to add one other thing here, the flip side of the major questions doctrine coin. This case is also, it may weigh in on what's called the non-delegation doctrine. And it's a judicial created doctrine that limits Congress's power to delegate the power to issue binding regulations to federal agencies. So it's very vague, and again, it's a judicial created one. And of course, that means that Neil Gorsuch embraces it fully, and he believes in the hollowing out of our federal agencies. So if we prevent Congress from delegating its powers to federal agencies, like, for example, to the EPA or every single agency, like with President Biden's current whole of government approach to addressing the climate crisis, under the non-delegation doctrine, that would be unconstitutional, because the court would say that Congress did not explicitly and use sufficiently definite and precise language that enabled Congress to do this. So therefore, it would not be constitutional. We know, even people who are not students of government, of the Constitution, knows that if you strip Congress of the ability to instruct agencies on their limits, what they can and cannot do, then really what are the opposite side of that is anarchy. Congress cannot personally, each member of Congress cannot personally weigh in on thousands and thousands of regulations. That's why the agency exists. That's why they hire experts. That is why they have an agency head who reports to the president, because in this nation of over 300 million people, we have now come to rely on our administrative state that, for better or worse, functions and keeps us going. So I just wanted to add that part in.
No, thank you for that. I think that's like additional context. So I think what you all are saying is that what this case is really about is trying to limit the scope of power of the executive branch to be able to allow federal agencies to enforce the policies and procedures that we have put into law, right? So that seems very clear why this, and also probably why this particular case is so appealing for conservatives to use this strategy. So thank you all for that. And so Tracy, to kind of build on this point about the impact for how we can address climate change, I really like to hear from you to talk about how will this impact like everyday Americans who are going to have to most likely bear the brunt of the impact if this case goes the wrong way.
I mean, today is definitely a sad day for the entire planet, right? We are feeling the effects of a single bad actor on a nation, and so my heart goes out to the people of the Ukraine. But and we are also seeing the same kind of tyrannical, authoritarian decision making that happened prior to the Biden administration. I won't even mention his name because you all know who it is. That a certain calculus happened. Like, the lives of certain people are irrelevant. If the deaths happen in blue states, if they happen in Black and brown and indigenous communities, well, that's somebody else's problem. And I fear that we have a court that reflects the person who constituted to be 6'3", and used every method to hijack it. Thanks, Mitch McConnell. So to quote Kanye, the Supreme Court don't care about Black people. Supreme Court don't care about brown people. They don't care about indigenous people. They don't care about poor people. They don't care about middle-class people. So we know these impacts already. People in frontline communities who live next to or in a certain radius of fossil fuel infrastructure are more likely to suffer a host of health problems, cancers, Cancer Alley, poor maternal health outcomes, low birth weights, early death, asthma. We already know all of these things. And that is with the powers that exist as they are, that at least people are able to seek some type of redress, may get some relief. So if those are the outcomes that we're suffering right now with this infrastructure or this framework, what in the world would happen without it? So just for example, since the start of COVID, we've seen a massive increase of deaths across the board in Black and brown communities because of the impacts of racism and lack of access to good medical care, et cetera. So there is no way that any of these things could be better with less oversight, with less empowerment of the people.
Thank you for that. That's right. It's not going to get better with less. But someone in one of our attendees put in the chat, if the Supreme Court succeeds at stripping federal agencies of power, who stands to gain, right? As Tracy notes, it's not the general public. The public loses many protections, and especially frontline communities. I think, and the person put rightfully so, I think we all know the answer, but worth calling out why this is happening, right? This is not a coincidence, as you all have laid out very succinctly, that this is a calculated decision, calculated case to take on, and that there are folks at play where, again, it's not about what we can legislate through Congress and through the executive branch, is what we can legislate through the judicial branch, because of this the least democratic branch of the federal government. So we've talked about this a bit already. I think you all laid out a lot of this But Andres, how might this case impact the federal government's ability to address other major issues? You talked about COVID as a good example. Are there other things that you could see in our future if this case is successful?
I mean, in all honesty, it's a little hard to say exactly what, because of just how broad or how narrow the decision could be. As Doug suggested, there's, even a ruling against our side could be more broad or more narrow. But I think the biggest concern that a lot of us have is that the court would make some sort of sweeping judgment on the major questions doctrine, or even on the non-delegation doctrine, which, as Tracy mentioned before, the non-delegation doctrine goes further, because the non-delegation doctrine is a constitutional limit on what Congress can do and the amount of authority they can give to an agency. The major questions is about what Congress in fact did do in the statutes they wrote. But non-delegation is about what the limits of what they can do are. And, the non-delegation doctrine, it exists. There have been cases that have struck down legislation for having been unconstitutional delegations. It's happened twice, and the last time was 1935. So it's been almost 87 years since there has been a case that the Supreme Court said, yeah, this is simply too much of a delegation of power to an agency. In that entire 87-year stretch, including a Clean Air Act case a couple of decades ago that was unanimous and said, no, this is an appropriate use of Congress's authority. Despite that, we have really aggressive efforts to expand the non-delegation doctrine, to use it in ways that it has never been used before, just, in addition to major questions. And so I think the biggest really concern is that some sort of sweeping opinion could sort of set a precedent in terms of the development of these, what seem like really abstract doctrines that could just make an open season for industry and for other opponents of regulatory action to just challenge one regulation after the other on the grounds that this is an example of something that has vast economic and political significance. This is too big of an issue. This can only be dealt with by Congress. And as everybody knows, the way that our Congress works this day and age, with a filibuster that establishes a 60 vote requirement for anything, means that it's very, very difficult to get most legislation passed through Congress. I mean, there's obviously some exceptions to that. And it's one of the reasons why Sierra Club is really, really strongly pushing for the Build Back Better Act, or whatever newest version of that is to pass. And just really quickly, I want to pivot to Sue's question about what can we do if the Supreme Court does the wrong thing. No, unfortunately, there really is no appeal to a Supreme Court decision except for a future decision to overrule that. I think I would answer that if the Supreme Court delivers an opinion that really limits EPA's authority in this case, what can be done? I mean, I think the agency has to be creative. It has to use other tools within the Clean Air Act, its Clean Air Act toolkit. It has to use this Section 111 tool in a way that complies with the court's technical judgment, but hopefully pushes as far as possible. I think passing, renewable energy funding, as Congress seems to have been close to doing and hopefully will do. Legislation currently pending would allocate $550 billion to renewable funding. Democracy initiative, voting rights legislation is, to me, absolutely key. Gerrymandering reform. I mean, so much stuff that I think a lot of people on this call probably feel very strongly about, but it's been disappointing to see what's been happening with that in Congress. But I think that to some extent we simply have to dig in and force the government to do everything it can within its toolkit that is not going to, that won't, even stuff that might seem like, oh, well, this a future court won't like this, or this seems like it would go too far. We still have to push forward, and we have to sort of conceive this as like, we have a small window to act to defeat the worst impacts of climate change, but we simply have to do everything that we can and not lose hope. I mean, I know that it can feel discouraging, to talk about just what the Supreme Court we have, what that looks like, the difficulty in getting legislation passed, but there are things that can happen. There is a lot of public support for this sort of action, and this is, I think, probably why groups like this and webinars like this exist, is to try to make sure that we don't lose momentum, even despite certain setbacks that might happen.
Yeah, absolutely. Thank you for that. And I kind of want to build on that with Tracy, kind of explicitly, how can and should Congress and Biden in the Biden administration respond? So Andres gave us a bit of a rundown of some of these legislative things. It'd be good to hear, what do you think the administration can do, depending on the ruling of this case?
I've literally been pondering that question. I think it's one that all of us who work in the progressive sphere are contemplating, knowing that should things not go our way, that it'll be very, very difficult after the November election to get more done. Like hopefully the House does not flip, hopefully the Senate does not flip, but it's very hard to say, and it looks kind of tough. So in terms with that, keeping that in mind, so what does that mean? That means that President Biden is actually very limited. And everybody remembers 2011, after the Obama midterms, and how we had a Republican-led House, but a Democratic Senate. It was difficult to move legislation, and he had to move towards executive orders for trying to achieve a lot of goals, especially between DACA. Oh my gosh, why am I just blanking out? But Google 2011. But so of course the as we know, executive orders, of course, are effective and they can be good, but they have a certain shelf life. And with the very well-funded far-right legal machine, they have a bottomless well of money to fight those EOs in court in a way that in previous generations may not have been as robust as it is today. So that makes it even more difficult, because the executive orders is the president's, the executive's greatest tool in intransigence and difficulty. So I think the best EO that everyone probably knows is when Truman issued the desegregation order for the armed forces, and it, did not go through Congress, but it also basically it still stands today. But many other EOs have not withstood that, and the companion to DACA for parents did not stand. So again, as I think both Doug and Andres said, that creativity from as we need creativity from the agency side, then we need creativity from the executive branch, because our government is a triangle. The executive branch sits at the top, and so even where its powers are constrained, it still has more power than the other two branches to a certain extent. I think that's going to take folks like my colleagues at Public Citizen, at Sierra, and America's Financial Forum, et cetera, all my great colleagues in the coalition universe, to start to think about ways to circumvent the far right, because they have spent 90 years trying to figure out how to unravel what FDR and LBJ put in place. And so we must put forth that same effort to counteract.
No, thank you for that. I would even argue before FDR, they've been trying to dismantle everything that we've tried to put in place. We had Reconstruction, and then Jim Crow, but to that point,
they're coming after the 14th Amendment.
Exactly. It's been a steady march. It's been a steady march to dismantle our democracy through a lot of the least democratic processes, is that the right word, to do that? So thank you for uplifting that. Someone in the chat brings up the point around, we can think about this as our legal strategy, but I also think that it's important that there is an outside strategy too, that they say that we, the people, are really pushing for these things. And all the things that we're seeing, this conservative judiciary, not just at the Supreme Court, but also in the lower courts, the decisions that they're making, the cases that they're taking on are overwhelmingly unpopular with the American people, right? So we are 60+% in support of access to abortion, but the Supreme Court says we'll hear that case, right? Americans are in support of COVID policies. The Supreme Court says, no, we're not doing that. We are constantly seeing voting rights, another great example. Overwhelming majority of Americans are saying, no, this is what we need. We need to really bake this into the system, right? Really make this a reality, and the Supreme Court says no. So again and again, we're seeing that this third branch of our government is working to dismantle so much that the other two branches are doing. And I know, Doug, you talked about this a bit. Tracy, you talked about this, Andres, as well. But Doug, I want to hear from you a little bit more, if you can, to kind of just name who are the conservative bodies in the legal movement that have been really shaping the strategy that we are seeing play out right now.
Thank you for that. And I think that's such an important question, and something that I think both Tracy and Andres have gotten at a little bit, because I think all of this is so connected. You really can't separate what the court is trying to do with our environment right now from the systematic generational assault on American democracy that we have been living through for decades. And in particular, if you remember, a decade ago, after the Supreme Court, this same court that is now more conservative than it was then, wiped away decades of campaign finance law and Citizens United, the FEC, we started hearing a lot about one particular family called the Koch brothers, right? Those two guys started becoming, and they weren't the only ones, but we heard a lot about them because they were giving so much money to support conservative causes, conservative think tanks, conservative university centers. There are hundreds of centers funded by this one family all across the country, in part to influence this exact kind of thing, not just our democracy and environmental laws, but our judiciary itself. And who are the Koch brothers? That family controls the nation's largest privately held oil company. That is where this is coming from. That is the kind of people this is coming from. And if we think about why it's an assault, not just on our environment, but on regulatory agencies in general, it's important to think about what parts of the United States government they want to dismantle, what parts they want to shrink, what parts they want to be able to drown in a bathtub, as we've been hearing for so long. It's not the Army, it's not the Air Force, it's not the FBI or the Department of Homeland Security. It's the agencies that protect the public from powerful private interests that in a democracy only a government can protect the people from. And it is those same interests and the people behind them and the people who stand to benefit from their ability to exploit the people who are behind this effort to roll back our environmental protections. That's what this is, and that's how we need to think about it. So we do need to mobilize, not just in the courts, but in the streets, in our elections, every election, and elections at every level of government. We need protesting. We need a lot of activity. I think the most important thing is we need everybody engaged, because the guardrails of our democracy and for our environmental protections, which are inextricably linked, are being taken down. And they're being taken down because the efforts against the people's interests are gaining more and more power every day. And we got to fight that power with our own power.
Yes, thank you for that. It's about how do we protect our courts have been taken over by the wealthy elite, and unfortunately the Republicans have become their puppets. And so here we are trying to maneuver around that. And I always tell folks all the time, the courts feel very far away from us because we don't directly vote for the people on the courts, but they have so much impact on our everyday lives in ways that can feel unsurmountable sometimes. So along that same line, Andres, just last month, the court agreed to hear another environmental case, this one about the Clean Water Act. Can you give us a preview of the issues in that case?
Yeah, I can. And I should say I'm not a Clean Water Act expert, but I do know the basics behind the Sackett case. And it actually has a lot of features of it that are similar to West Virginia v. EPA. But the Sackett case, basically it asks whether EPA, under the Clean Water Act, EPA and the Army Corps of Engineers, they jointly administer that statute. What is the extent of their authority to protect wetlands under the Clean Water Act? And there was a decision from the Supreme Court some years back called the Rapanos decision that really created a lot of confusion on this point, because there was no opinion that carried a majority of the justices. There was one opinion from 4 of the conservatives that would only permit EPA under the Clean Water Act and the Army Corps to regulate wetlands and require parties to get a permit under Section 404 of the Clean Water Act in order to fill wetlands with soil and dredge material and other such things, if in fact that wetland had a surface connection to some body of water that could be considered navigable and therefore within Congress's commerce authority. The decision by Justice Kennedy wrote a concurring decision that would have allowed EPA and the Army Corps to regulate those wetlands if they had a significant nexus to a navigable body of water, but not necessarily, it didn't necessarily have to be a surface connection. And the liberal justices basically would have permitted the agencies to regulate wetlands under either of these circumstances. And so the Obama administration interpreted this, that took the significant nexus, the more sort of broadly, the broad test. And they said, this is how we interpret the Clean Water Act. This is how we regulate it. This is what authority we think that these agencies should have. The Trump administration went in the opposite direction. They contracted the agency's authority by throwing out that earlier regulation, replacing it with one that would only permit wetlands regulation if there was some sort of semi-permanent surface connection in terms of surface water between the wetlands and the navigable waterways. The Biden administration has withdrawn the Trump rule and is replacing it. And in the meantime, the Supreme Court has agreed to review this question, even though similar to the situation that we're dealing with in West Virginia, the Biden administration has not yet actually issued the regulation in question. And so this really would go to what is the extent of the agency's authority to protect wetlands. And it's just another situation in which this was a case that in many ways, I think a lot of commenters thought that the court should not have taken, that there really is not necessarily a justiciable controversy or case here for them to hear, and yet they went and did it anyway. It's another very aggressive cert grant. Cert meaning the process by which the Supreme Court agrees to hear a case on appeal. One of the things I think is worth noting is that, it's a critical thing is also that President Biden gets all of his judicial appointments filled, including the vacancy on the Supreme Court that we're expecting. I mean, it is absolutely critical that seat be filled as quickly as possible. And we don't know who the nominee is, but we are going to be pushing strongly for that position, that position to be filled. And also, one of the things to remember is that the DC Circuit, the US Court of Appeals for the DC Circuit, it's sometimes referred to as the second most powerful court in the land. I mean, technically it's on the same level as all courts of appeals, but it's really, really important because that hears a lot of the cases involving federal agencies, involving EPA, involving the FDA. A lot of those go immediately to the DC Circuit when there's some sort of regulatory action that's being reviewed. And the DC Circuit is actually one of the courts that Trump was not really able to change the fundamental composition of. He did appoint some judges to that court, but they were basically replacing ideologically similar judges. And that court actually is one that tends to be a lot more sympathetic to the kinds of cases that we hear. And the reason that I think that's important is just because, I said before, agencies need to do creative things. To some extent, things like, really to a very large extent, things like the major questions doctrine and the non-delegation doctrine, those are signals, those are the courts saying to agencies, don't try anything creative, don't try anything cute, But the fact of the matter is, agencies can do a lot of stuff. A lot of that stuff goes to the DC Circuit, which is a fairly sympathetic forum, and the Supreme Court can only take so many cases, right? They cannot hear, they only accept a relatively small percentages of the cases. Oh, sorry, I accidentally muted for a minute. So I think strategically, we need to encourage agencies, even if there are things that sort of general auras coming from the Supreme Court that are sort of saying like, there's a new sheriff in town, agencies are restrained, they're not going to be able to hear everything. The DC Circuit is a court, and that's why we won in West Virginia for EPA. We won in the DC Circuit before, 2-1 before a 3-judge panel. And so, just another way of looking at this is things like, the Sackett case actually came out of the 9th Circuit. So it's not across the board all out of the DC Circuit. But the point is that I'm not advocating that the government like explicitly disobey a Supreme Court order, but I am saying that if there are ways of interpreting Supreme Court judgments that allow agencies to do things, that maybe a future Supreme Court decision would look disfavorably upon that, as long as they're not doing something that is explicitly against an order from the court, I think they need to really interpret their authority broadly and creatively, and rely upon the fact that lower courts are sometimes going to agree with them. And maybe the Supreme Court, like we should not assume that we're going to lose this case. It is a conservative court, but we also have some justices on the court that are concerned about, some of the conservative justices are concerned about the institutional legacy of the Supreme Court. They are aware of the fact that the public opinion of the Supreme Court has fallen precipitously in recent years. They're aware of the fact that, there may well be out of step with a lot of what happens with the public, and that there's only so much that, if they really want to just tarnish their own legacy, and they can do that. And some of the justices don't seem to care about that, but some of them do. So I think that we should just realize that, all of these cases that we think we have a conservative court, I am not assuming that we are, I think that we have made a persuasive case, and the Biden administration has made a persuasive case in our briefs. The oral arguments will be on Monday, and I have high hopes for that. So we'll see what happens. Obviously it's hard to sometimes to know what's going to happen, but I'm still retain hope.
No, that's awesome. You have to have hope in this. It's one of the folks put in the questions about how when progressives talk about these things like this, like the house is on fire, people look at us like we're crazy. But that's why we do this work, is that we continue to sound the alarm. And I think to build on that, a lot of the conversation has been about it. What I'm hearing is about how the system, the court itself, is broken. Like that is not an institution that is actually upholding its end of the bargain. A part of what the Constitution set it up to do, or what the government set it up to do, it's not holding up its end of the bargain. It seems like it's tilted one side. So Tracy, your organization has endorsed the Judiciary Act of 2021, which would add 4 seats to the Supreme Court. How did you all come to this as being one of the remedies to this broken Supreme Court, and a tool into really reforming it and bringing about the kind of structural reform that's needed so that these types of cases are not used to dismantle our democracy and the policies that we, the people, have put in place?
Oh, thanks. That's I'm proud to be part of an organization that supports court expansion. Although the decision happened before I came on board, but I can just share that it was one, I think that was probably a very logical one for a public citizen to come to. One, we have a really robust litigation team, so it helps that we have just a ton of lawyers already on stack, ready to go, who understand what the great constitutional theorist Alexander Bickel called the counter-majoritarian difficulty, that where my common law professor is going to love that I still remember that. And the counter-majoritarian difficulty or dilemma really refers to the legitimacy of the Supreme Court is constantly, it can undermine itself where it acts to nullify decision-making from the executive or the legislative branch. And those two branches are majoritarian. They are democratically elected. The people wanted certain things to happen. They put those officers in place to do it, and the court can come and cut it down. So, as Andres just referred to about the court's legitimacy, and how some justices understand that decisions that they're making can serve to ultimately undermine their authority. So with court expansion, which Congress has done multiple times in the history of America, and has shrunk it as well, by expanding it by 4 seats. This time we are making it less likely for moneyed interests like the Koch brothers to be able to manipulate it by putting on one or two people. I think most people on this call, I'm sure, are like SCOTUS nerds like I am. And they remember in 2016 how Mitch McConnell ensured that Merrick Garland did not even get the courtesy of speaking to other senators, let alone even being given a hearing with an up or down vote, which we are also seeing being done again now. This is a new tactic of the far right to shut down our government so that certain decisions can't be made. So with the larger court, and also just a historical note, FDR tried this. They call it court packing, but really at that time when FDR was trying to implement all his New Deal policies, he was met with the same moneyed interest. J.P. Morgan, Andrew Carnegie, all of those people were trying to stop progressive policies from being put in place. They did not want to see Social Security. They did not want to see, they didn't want to see anything that was good. So nothing has changed over 90 years. My mother was born in the 30s, and very little has changed. So we support court expansion because it will make the court more responsive to the people, less likely to fall sway to these moneyed interests. And just one, other last thing, as we know, Republicans have lost 7 out of the last 8 presidential elections, yet they have been able to appoint 15 of the last 19 justices. There's the counter-majoritarian difficulty right there, that the party that was not put in the executive branch has controlled who is on the bench, and it has shaped it to be a dark and twisted place that has a shadow docket that does not even respond to what's going on in the courts, the lower courts. So that's why this is important. The 6-3 supermajority.
It's 9 o'clock.
Sorry, that's the ghost of Steve Jobs talking to me. But with the 6-3 supermajority, it is so important that we restore balance to the court and let the court reflect the will of the people who we put in office.
Well, thank you so much for that, Tracy. And thank you, Andres and Doug, again, for joining us this evening for this really important conversation. I feel, of course, it's very timely, but you all just dropped so much knowledge. And I think that it's really important to put all this into context. Oftentimes, I know for me, oftentimes with court cases, they kind of just come out of nowhere. But of course, there's a strategy. There's not a coincidence that this is the case, right, that we're hearing about. And this is the case that the Supreme Court has taken up. And knowing who's behind these cases is so critical in understanding what's really happening in our country and in our democracy. One last push for the event this coming Monday and for the Supreme Court at 9 a.m. Join other activists who care about our climate, the future of our country, the future of our democracy in front of the Supreme Court. I'm going to drop the link again in the chat for everyone to, if I can find the chat. Here we go. So please, RSVP, join us 9 a.m. in front of the Supreme Court. There will be oral arguments that morning as well. And so just thank you all again. Thank you, Tracy, Doug, and Andres for joining us this evening. And to everyone watching, have a good evening. Talk soon.
Thanks, everybody.
Thanks so much. Great
Thank you.
pleasure. Bye-bye.